The hearing was called by the group of disappeared and detained family members, AFDD, London 38, Espacio Memorias, Sons and Daughters for the Identity and Justice against Oblivion, and Mr. Pietro Starasa Tavi and Karina Fernandaniera. My name is Julissa Mantilla. I'm here as the rapporteur for Women, Memory, and Truth. I'm also here with the Human Defender rapporteur, Mr. José Luis Caballero, and Tania Román, the Executive Secretary. Greetings to the State and Civil Society members as well, and Jan Harab, who is the regional representative of the UN High Commissioner for Human Rights for South America. He's going to be participating in this hearing virtually. I think he's connected, as I'm told. The purpose of the hearing is to provide relevant and updated information in connection with persistent obstacles to justice and reparation in the context of Chile 50 years after the beginning of the civic military dictatorship. The civil society will have 20 minutes, the state 20 minutes, John Yarat from the UN 7 minutes, then the commission will have 10 minutes, and we're going to have a second round of comments. Having said that, I will give the floor to Civil Society. Please introduce yourselves as you take the floor. Good morning, Commissioner. Thank you very much. We are made up by Elga Hennings. I'm the director of London 38, Ruth Vargas, and Karina Fernandez, a human rights defender. We are all going to speak today. The request for the hearing and the report we're going to send the Commission is a result of joint work of all of the organizations and individuals and that have put this application to you. Ms. Veronica De Negri, who is the mother of Rodrigo Rojas, is here today. He was killed in Chile during the dictatorship. We are going to submit to you a number of topics that are included in our reports that we are going to then send to the Commission. Thank you. I'm Erica Hennings. We are going to talk about crimes against humanity in Chile and the shortcomings of the state. And this has to do with one of the concepts, impunity. Also value, perseverance, love, and hope. In spite of it all, from those women who have for decades and decades continued to demand and ask where they are. And of course, we're dying off. 50 years have transpired since in 1973, a brutal dictatorship was imposed in Chile, and it ended a democratic government, and it ended popular mobilization and social transformation processes by a civic military coup d'etat that impacted a whole country, the social body of the country, and the body of each individual. There were people executed, disappeared, and tortured. Others survived as mothers, as wives, as witnesses and activists. We have today a few minutes to give testimony of these past 50 years, and we thank you for that. The consequences are part of our present in different spaces, social and policies, and we are going to talk about the family members and the mothers, fathers, wives, and grandchildren who are looking for truth and justice. We have about 1,000 cases that are being dealt with by the courts, by the trial courts, and these were put by these women. Sometimes amparo remedies were denied. There were dismissals. There were statute of limitations against their cases. Many of them had died already without knowing that their case ended, oftentimes without revealing all the truth. Some of them are 100 years old, and they were fighting for their lives, and they are waiting with some resignation, and they have fought against memory, but some of them have forgotten everything. Alzheimer's and other diseases have gotten to them. Although the cases have ended and they may find their parents or children, they don't understand what happens anymore. The state recognized that disappearance was not a private problem, but it was a debt that they had. So we have the plan of fight, and we have biological impunity as well. We have women who are between 90 and 100 years old, and they're going to die, and impunity is going to continue. 50 years have transpired, and some convictions have been given, but some of the convicted individuals escape, and they were not able to be notified of their convictions. This, of course, has to do with kidnappings and people that have been witnesses to the detentions of their friends and also fellow companions. And they have had to face their own perpetrators. But for many years, they could only give testimony about those who did not survive, 1 in 1,000 times against the courts. And they admitted their own damaged bodies. The family members of the witnesses that were part of civil society got involved in trying to look for the truth because the state was not doing it. And they did it trying to look for people in the desert, going to the Arteaga fort with data that we're trying to obtain. Some of them came to talk to the collaborators of the repressive apparatus, trying to ask them to break their silence. We had to know more about the machine of death. We had to know what happened in the very end. And also we had to know what happened to the hundreds of people that disappeared, although they deny that they disappeared. The state does. So not everything was in vain, right? So we were able to know about their names, the structures, and since the 90s we got more information. There are some pacts of silence. There is procedural backlog in judicial investigations that are not related to the final destination. And the survivors that have been witnesses in the trials of the disappeared persons, they are there, and they have disputes for indemnities, and they are trying to put their claims even here at the Commission. The Commissions of Truth and Qualification worked for limited periods of time, and some of the victims were not able to know where to go or when to go to places, and they were not able to present appeals. All of the testimonies and documents submitted to the Valich Commission were declared secret for 50 years. And as we told the Commission, the Truth Commissions did not address cases and consequences of sexual torture. And the family members of the victims of forced disappearance in Chile have tried for many years to try to find spaces for participation and of influence in the administrative and government contexts, as well as in the courts. They were trying to look to exercise the rights and to find their family members that had been victims of all these acts. And this has, of course, impaired them personally and socially. Their voices have not been heard oftentimes, and they see that there are great vacuums in the development of public policies, and this affects new generations, the grandchildren and the great-grandchildren. Unfortunately, forced disappearance in Chile has not been rooted in democracy. We have seen grave violations of human rights in the past few years, and this evidences the political insufficiency to prevent and ensure the non-repetition of these events. We have 1,469 disappeared individuals, and civil society needs to know the truth, and those responsible need to be adjudged. And There has to be disappearance for the damage suffered. It is necessary to understand comprehensive reparation in connection with international law and in accordance with its principles, because this has to do with the victims of political prisoners and torture. It is important to assess the quality of reparation programs and also optimize public policies related to the benefits provided to families and to the society as a whole. Society must be witness of the obstacles and vacuums that exist in order to access justice. After looking for evidence that was in the past lost, and after getting all the evidence from victims of disappearances that were not assessed by doctors. The dictatorship crimes have left a transgenerational damage, and the rapporteur on torture visited Chile recently, and she saw how society in its entirety suffers these damages. That's why we urge the Commission to consider the comprehensive reparation, the transgenerational aspect of damage. And we have to say that we are looking for family members, and that generations are impacted. There is an intergenerational and transgenerational impact. Also, we have to say that communities have permanently been damaged because of the absence of the individuals disappeared, and damage has impacted the relationships between families and governments, and this leads to negligence. This also worsens the emotional damage that family members have suffered, and this, of course, perpetuates the psychological, moral, social, and economic outcomes. So the impact of growing up in a family that describe what happened to some of the family members in horrific acts, this creates damage that undermines basic human structures. Young people also see that there are barriers to access to justice and the asymmetry that exists between the powers of the state and the needs of the family members. And that is why we also have to think about the Mapuche people, and their territories are in a state of undefined exception. So this threatens the integrity of the family members of the victims of individuals that have disappeared. We ask the Commission to push forth a regional debate in connection with the importance of the characterization of the effects of forced disappearance of family members and the transgenerational impact, and for this to be qualified as torture. We can say that this is torture because the family members must live permanently in this state of anguish and uncertainty because they're trying to look for their loved ones at all times. So we need to limit the impact of the impunity of crimes on their family members and any negligent act. And we need to mitigate the economic, social, and emotional effects that are the consequence of forced disappearances. Political prison, torture, and we have to understand the importance of the effects of crimes against humanity and their consequences after 50 years. In connection with the crimes of the past, we see the same set of regulations, city limitations, and other things. The crime of forced disappearance has not been classified as an autonomous crime. We have seen things that have gone beyond kidnapping, and we know that some victims were in clandestine centers. We have not addressed the full dynamics of disappearance. Some crimes were not investigating by the media in the 1980s. We still need to have investigations as to how they operated and what criminal patterns they applied. The court cases are isolated and they focus on specific victims that do not look at the macro crimes and other large crimes such as forced disappearances and torture. We need to get information from the agents that conducted repressive acts. The criminal courts look at investigations that have to do with simple crimes, and they tend to limit criminal prosecution to those who gave or got orders. Either, subordinates or those who provided the orders. So we find a number of people who were impune, and they continue to be impune. And there is no database that systematizes the information contained in the court proceedings or police reports or the information provided by the armed forces. We need better investigation procedures. If there are no findings, protocols are useless. We need to have new technologies in connection with forensic work. And many of the perpetrators that were convicted have left the country. When we were able to find them overseas, in spite of the efforts for extradition never happens. Carlos Minoletti, in the case of Leopoldo Garcia, he was prosecuted and he died without any punishment. The Foreign Office never accelerated its return. In the case of Mr. Haltori in Italy, he had once the extradition was approved, he left for Germany. And then, thanks to the Argentine police, he was returned to Chile. There are some land crossings that do not update their information in connection with the captures, in connection with the victims of torture and sexual violence. There have been crimes against them, but there has been a situation of lack of punishment. Some torturers have seen their cases, processed and convicted, and of course, since 2008, some individuals have not been punished. Some cases were closed, and then they had to be reopened a number of times by the victims and their representatives. So, to evidence tortures, tests were asked of the victims that did not apply the Istanbul Protocol. After 30 or 40 years, vaginal tests were asked. In 2012, when the Istanbul Protocol began to be applied, this changed, but there is a lack of professionals in the field of mental health in certain parts of the country, so it's difficult to get a date to get your test done. Actions usually have to do with cases of illegitimate loss of liberty and other cases. Sometimes, however, the victims had suffered from other acts such as, sexual abuses and other issues. So sexual violence actually made this practice invisible, specifically in the case of women. There is no protocol to get the reports from these victims. In Chile, we have no state agency that provides specialized social processes to those that have been part of the fight. They do not have any kind of place to ask for benefits. We have a report that we are going to provide to the Commission, but we would like to ask the state of Chile to be reminded that there's a report in the case of Sol, and that has to be fully complied with within the terms established. The state of Chile and the judiciary of Chile must implement all the necessary measures to strengthen all institutions that are involved in judicial prosecution, reparation, and measures of non-repetition. For example, legal services, the service of investigations, etc., and for all these agencies to cooperate amongst themselves. Also, we need to implement the national search plan, respecting the international standards of the matter, and also to respect the rights of family members and victims and their right to participation, and to create a model of management in the context of the plan that is transparent and that includes human resources and materials for each one of the stages and year of execution. This needs to be allowed to be audited by civil society organizations and by the family members. Thank you very much. Thank you very much to the members of civil society. I'm going to give the floor to the state for 20 minutes. Thank you very much, Commissioner. Members of the Organizations of Human Rights of Chile, Mr. Rapporteur, Executive Secretary, the delegation of Chile thanks you for your presentations. Thanks to the civil society members for the presentation and their leadership in this hearing. And this is not by happenstance. There has been courage and perseverance by the family members of tortured individuals, and this has moved forward, and it has prevented our country to have full impunity. And thanks to these organizations who have mobilized the state, as they're doing today, and Chile reaffirms its commitment with the human rights system, and it recognizes the fundamental task that the Commission has today, as it did it before in 1974, when it called the attention of the international community on the facts that were and events that were taking place in Chile. Chile has moved forward slower than necessary. It failed in providing opportune reparation measures. So we recognize that there are problems in connection with the seek for justice and reparation. The administration of President Boric is committed to human rights. Mario Carroza Espinosa, the Justice of the Supreme Court, is here, and this shows the joint work that has been done on this issue. After his presentation, the head of the Protection Division of the Undersecretary of Human Rights, Ms. Daniela Quintanilla, is going to talk about price. Also, the medical legal service and the police service, and then the head of human rights of the Secretary of the Human Rights Program, Ms. Zamorano, is going to take the floor as well. Mr. Carroza, you have the floor. Good morning. I'm here before the Commission in order to represent the judiciary and in my capacity of Justice of the Supreme Court, in charge of human rights cases for the period going from 1973 to 1990. And I undertake this challenge in order to provide to you the information that the judiciary has so far, and the difficulties in the investigations and the redress of these crimes. Most of my court career has been devoted to find out how agents of Chile brought about acts of death and disappearance of individuals during a period of time that was quite long in our country. Many of us had to undertake this task, and we do so with a resolve and commitment. In 2013, and the Supreme Court recognized the fact that between 1973 and 1990, the judges didn't do enough to determine the effective nature of the crimes committed during that period. The court has made its best efforts to clarify those crimes, and it urged all of the judges of the Republic and members of the judiciary to take to the task. I am aware that there are pending matters in connection with convictions and prosecutions, but I am convinced that the judges that hear the cases are motivated and are trying to deal with these cases. We have 1,300 cases that are still pending at different procedural stages that have been distributed among the different judges. I think it is important to recognize the tenacity and persistence of the victims' associations. Some of them are here for the judiciary to provide redress to their claims for justice. The Office for the Coordination of the Cases before the Supreme Court has decided that any person that would like to get the information that our agency has can get that information. That is why I contacted all of the victims associations in Chile in order to let them know what the coordination office does and to listen to the victims' representatives and to hear their opinions as to how the cases are progressing and also the type of connections that we're having with the different judges. I also kept them abreast of what was happening at the Supreme Court level. The head lawyer of the Human Rights Office was asked to provide to the victims' organizations any information they may need and also to help them in their cases before the Supreme Court and to also get direct information from the victims' organizations so that they can get an opportune answer to their requirements. It was also considered necessary that we need to take one step further and to have them visit every single human rights judge in Chile. This was done in 2023, and this was completed as well. And the criminal chamber of the Supreme Court has moved ahead more quickly in dealing with cases that were part of the backlog, human rights cases. And this was a constant requirement by the victims' organizations. Together with the requirements, the Supreme Court on 3 October 2022 decided to expedite cases, and it decided that the measures to expedite cases be dealt with forthwith. From January until 16 October 2023, 74 remedies have been heard by the court. This is an increase in connection with the 32 remedies that it dealt with in the year prior. So we not only have to deal with case backlog, we need to assist in the finding of victims of the dictatorship that have disappeared, and the government of Chile has committed its assistance in every single stage, in particular in connection with the information it has digitally, and also for the creation of a database that together with AI can create useful information in the task of investigation. We have had visits with the judges within the context of the Ministry of Justice, and we have worked with them in the field of human rights.
We also agreed upon the activities to be implemented and the way in which each agency will have involvement. Also what the different groups will do. Another concern of these groups has to do with jurisprudence and the Supreme Court. The Supreme Court has maintained that it is appropriate to provide a reparation to the victims and those who are family members of these victims of the period 1973-1990. Grandchildren have been included as well. This position has been established based on the remedy put forward by Chile, represented by the Defense Council of the state. They have said this is not appropriate because they are not direct family members of the victims. But the criminal area of the Supreme Court has done away with this interpretation and has granted indemnities to family members of victims independently of the closeness of this relationship. This reparation has not been built based on special reparation laws. On the contrary, this is based on the personal detriment suffered by these individuals given the victim status of their family members. The state is to cover those reparations in agreement with international law. From our position, we will continue to do everything possible to continue to move forward in a timely fashion to work when it comes to crimes against humanity, both in the criminal plane and also in reparations. Thank you, Minister. On the reparations program and what we call price, this comes up in 1990 as part of the public policy of reparation for individuals and families affected for human rights violations during the dictatorship. It aims at contributing to the biopsychosocial reparation for those affected by state terrorism. At first, their children, this was broadened to include grandchildren and cousins of victims. As of June 2023, the number of beneficiaries has exceeded 877,000 individuals. These beneficiaries can have access to comprehensive care, health care throughout the public service. There are also 42 mechanisms at the national level to provide specialized care. This system is focusing on social and mental health damages, also considering the evidence of torture that brought about dental trauma. PRICE is a policy of permanent reparation, a continuity program for life. That is to say, beneficiaries can have access to these services throughout their lifetime. With regards to the resolution of waiting lists, the prioritization of cases deals with clinical criteria based on the health situation of the patients. Since 2014, we have given priority to providing health care to former political prisoners, making every effort to give priority to new consultations. In 2019, we also included as a resolution component for the waiting lists the first generation, that is to say, those directly affected. Today, we have a price commitment for 2024 aimed at the three aspects of the program. First, the resolution of the surgical waiting list. Second, institutionalization and functioning of PRICE in health services. And third, the focalization and prioritization of special care for political prisoners, victims of torture, their family members. On the other hand, and for a better implementation of the program, the budget assigned to PRICE has increased each year. It has exceeded 7 million pesos for 2023, which is an increase of 8.8% regarding the previous year. However, we know we need to provide greater coverage to this program. With regards to investigations and the role of the legal medical service to identify victims, they have 40 offices throughout the country and over 1,000 officers who carry out this job. The expert technical work where it comes to crimes against humanity follows the guidelines in the Minnesota Protocol. Regarding the progress made in the identification of victims in the case of Patio 29, We undertook the commitment of carrying out genetic analysis in foreign labs. We have also incorporated the use of one of the techniques that has shown to be the most precise, which is the use of carbon-14 for dating. Regarding findings and identifications, we prepare a comprehensive report answering the questions ministers or judges may have posed. We are aware that together with providing information to justice, we need to also guarantee that this will be given directly to family members. Under the framework of our national search plan, we have steps to do this and create tools and protocols vis-à-vis family members to guarantee their involvement throughout the search process. Finally, it is worth pointing out that the legal medical service is undergoing a modernization and strengthening process, improving its infrastructure through the standardization of its processes to improve the forensic work at the national level, including those related to human rights. To conclude briefly on the work of the agencies that cooperate with this, we're aware that we need to reinforce the work of police officers. We have had in 2021 the creation of the section to investigate crimes against human rights. This is the operational response at the institutional level. We are committed to continue to work in this sense to have an appropriate investigative job. Good morning. There are in total 2,400 people who were forcibly disappeared in Chile during the dictatorship. Of these, 307 individuals have been found, identified, and brought back to their families. Hence, there is a universe of at least 1,772 individuals who have not been found yet. It is for this reason that in June 2022, the President announced the creation of the National Search Plan for victims of forced disappearance during the dictatorship. It is the Ministry of Justice and Human Rights in charge of this task. We carried out a participatory process to get the input from victims and family members' organizations, and to also see the progress that has been made so far. These groups are the ones that have led the search for those victims of forced disappearance. This national search plan would not be possible without you. We also worked with academia, civil society organizations, and other stakeholders. We had 67 meetings throughout Chile with the attendance of 775 persons and 5 thematic workshops with about 5,000 attendees, both in person and online. The National Search Plan is a public policy tool to have truth and justice vis-à-vis disappearance and torture in Chile during the dictatorship. We look at the efforts of the state setting goals, terms, and those accountable for the implementation of the plan. The general objective is determining the circumstances surrounding the disappearance or death of the individuals in a systematic fashion and in a permanent fashion consistent with international standards and Chile's duties. Among specific objectives, we have the clarification of the circumstances through the reconstruction of the forced disappearance trajectory of these individuals. We want to know what happened from the moment the person was detained until the final destination. We want to know also the macro-general patterns of forced disappearance. We want to establish truth and also determine who are those responsible of every crime associated to forced disappearance. We also want to guarantee access to information and the involvement of family members and society at large in search processes, both for search hypotheses, training processes, and restitution. Also implementing reparation measures and guarantees of non-repetition of these actions. We will adopt the following measures. First, the creation of the governance structure of the National Search Plan with a committee that will be in charge of following up on this with members of civil society, and the application of the human rights organs for the implementation of the plan and the cross-sectoral coordination. 2, the creation of an operational roundtable with institutional stakeholders who are part of the search for victims of forced disappearance, with the goal of coordinating the actions of the plan and also the level of execution the plan has. 3, the creation of a technical working group that will identify the different documentation found in state institutions for their analysis and systematic approach for the human rights plan together with civil society. 4, we have the design of the platform for the national plan. This will be an analysis tool and also to cross-reference information and the use of artificial intelligence. We expect to have the first deliverables from this system in December this year. Also, what has to do with the human rights violations cases, we will have a national meeting to tackle different topics, for example, planning on work on the ground, prioritization of criminal records, and preventative measures to prevent that these individuals who engaged in these actions managed to escape or evade justice. We want to work in coordination with the Legal Medical Service, the Human Rights Program. We are carrying out a register with sites of interest. It is important to point out that the demands put forward by civil society and organizations will be considered by the state. We appreciate this space of dialogue. We want to move forward to satisfy these requirements by civil society. We want to take one more step in the context of the 50 years since the coup. I give the floor to Jan Jarab from the UN. You have 7 minutes. Thank you so much, Chair, commissioners, representatives of the Chilean state and civil society, in particular human rights advocates, victims, families, and survivors of the dictatorship. Good morning. It is an honor to be with you today. This year, when we commemorate the 50 years since the coup in Chile, it is worth pointing out the contribution of human rights advocates in Chile and the hemisphere, and the contributions they've made for the creation of the international human rights protection system. The magnitude of the human rights violations carried out by the Chilean dictatorship fostered the creation of several human rights protection mechanisms, such as the Working Group on Forced Disappearance and the Special Rapporteurship on Extrajudicial Killings, also arbitrary and summary executions. These mechanisms continue working throughout the world. Since the return to democracy, the Chilean society has moved forward to tackle the terrible consequences of the dictatorship. However, as mentioned, there are considerable challenges still in all of the transitional justice pillars. Large part of these pending issues are chronic in nature and continue re-victimizing victims and those who have put forward claims on their behalf. We consider it worthwhile mentioning the recent efforts undertaken by the government. It is worth mentioning the launch of the National Search Plan, through which the executive power undertakes responsibility for searching for those forced disappearance victims. Before, that search had been carried out by family members and some members of the judiciary, to be highlighted for their exceptional commitment. It is key to carry out the search following the main principles on the search for forced disappearance victims, and to bear in mind the experiences of the different countries around the world, in particular Latin America. These principles emphasize the involvement of family members of victims. It will be essential to have close coordination and cooperation with every state institution, including the armed forces, which must provide access to their files. It is worth pointing out the announcements of a legislative agenda with draft bills that will consider the legal status of those who are in absentia given their forced disappearance. Also, what has to do with those tortured and political prisoners, and the fact of living without effect laws that considered files confidential. All of these aims at removing certain obstacles to reparation. It is still pending the establishment of a permanent commission for victims to enable access to reparation measures. This recommendation has been reiterated throughout the decades by victims and human rights mechanisms at the UN. With regards to the justice system, we notice the greater speed mentioned by Minister Carroza. We see some rulings in cases such as that of Victor Jara and Carlos Villa, the UN official. However, decades have been necessary to get to these rulings. Large part of these delays had to do with the obstacles posed by the amnesty law. The Inter-American Court issued a decision on this, ordering the state to ensure that the decree will not continue to be an obstacle when it comes to the investigation and punishment of human rights abuses perpetrators. This is no longer an issue to sanction the authors of these crimes, but the rule remains. We are still concerned about impunity when it comes to human rights violations, in particular torture cases, including sexual torture. Also, the pending ruling on several cases. We are also concerned about the fact that a growing number of convicted authors of these crimes are not to be found. Where it comes to memory, we are encouraged by the joint declaration between President Boric and the 4 previous presidents, highlighting their commitment vis-à-vis human rights. We are concerned, however, about those who try to minimize the seriousness of these actions and to blame the victims. It is essential to condemn these serious human rights violations in an unequivocal fashion. Nothing can justify grave, generalized and systematic human rights violations such as torture, extrajudicial killings, forced disappearance and arbitrary detention. And we cannot allow either that these actions are relativized. We see that there need to be minimum standards that derive from the dignity of each and every person. I conclude by reiterating our deep solidarity with the victims and the commitment of our office to continue to cooperate with the Chilean state in these processes. Thank you so much for your attention. Thank you so much, Dan, for being here today and for your precise use of time. Now we will listen to the Inter-American Commission. I give the floor to Mr. Caballero, rapporteur for the country. Good morning, everyone. Good morning, Chair, Julissa Mantisha, Tania Renaud, Executive Secretary, Civil Society, the State, the representatives. It is a pleasure to be here. I support your cause of so many years, your dignity and your work to get to truth, justice and reparations for the victims. I'd like to begin, and also I want to greet the representative from the UN. It is a pleasure to be here with him this morning. I'd like to highlight the role Chile has played in the truth, justice and reparation processes, transitional justice. Chile has been a significant actor for the region in this field. I remember the Monastir case, not only the control of conventionality, but also some things that have to be progressive, not having any backsliding where it comes to punishing crimes against humanity. Also showing that military jurisdiction doesn't apply, and some elements. We have to have a certain floor that we cannot move from. Listening to civil society representatives, the state, and victims' representatives, I'd like to tackle three elements. First, the judiciary. And I am very pleased with the attendance of the minister this morning. It is very significant to have someone from the judiciary here at the hearings. I'd like to ask you if the judiciary as a whole, not just the court, are the cases being taken with protocols so as to, for example, issue rulings through a gender lens, or to have a specific perspective when it comes to serious human rights violations? Has the judicial system in Chile been trained to do this and from the get-go be able to work in a good way? I'd like to think not just about the Supreme Court, but the system as a whole. Secondly, I was concerned about something civil society representatives said about the fact that forced disappearance is not autonomous and sexual torture is not categorized as a specific crime. I'd like to get some information on this and how these crimes are categorized and what is being done by the legislative branch to that effect. Secondly, and celebrating the new search plan, I believe this is so important. I'd like to ask about the support you have with a forensic service to work on the findings, because what we are seeing with search plans, we see state agencies entrusted with this work, but they do not have a technical, skilled forensic team. Even if the legislation aiming at the search is very sound, things happen. The results are not expected. So could you please address those three elements? Thank you, Rapporteur. I'll pose my questions now. Greeting once again the state and the women in civil society organizations here, because it's always women, and this is not by chance. We see this in Argentina, in Colombia, here. We want to acknowledge your permanent fight and say how many times you have forgotten your own bodies or the torture you suffered in the search for your family members. I'd like to ask the state, what specific measures are you undertaking to acknowledge the situation of these women in Colombia? There is a program for women who search. In Brazil, these women have asked for the same thing. This could be an initiative to take into account. Secondly, the issue of sexual torture. You had the Balech, Rettig, all of the truth commissions, and Villa Grimaldi. You have that information. My question to you then is, how are you investigating specifically, besides the gender lens, the cases of sexual torture during the dictatorship? And I read the reference on the case of Plaza Constitución and sexual violence. This happened this year. But this is a case from 2010 and 2015 afterwards. And we know this because I was in Chile when that was being considered. And it is very good that this ruling has come to be. And as Vallejo was saying, why not think about a specific investigation area for sexual violence during the dictatorship? If we know that that happened, maybe there could be an initiative, maybe a specific or a truth commission, because Nunca Más in Argentina and Balej and Rettig had no gender lens, but after Peru and Colombia, this can be investigated. I remember the Rettig report where they said talking about sexual violence is so hard. So the report covers what victims wanted to say or were able to say. But if things are known, why not do something about it? The second issue about the transgenerational damage is so important. That is such an important initiative. As long as the wound is open, that damage continues to be inherited and perpetuated. On the other hand, amnesty laws, they are not applied, but they continue to be in effect, and that is a symbolic wound that is inherited from the dictatorship. Even if it's not applied, some of us are lawyers here, it could be open at some time. Having that open wound, well, it would be so important to put an end to those laws. Jan Jarab was talking about the possibility of categorizing as crime forced disappearance. This is important, but I believe right now, all of the investigation and what you were saying, women, those women who have been searching, and so many of them are dying. Why not think from democracy for a special initiative? I was thinking, and with this I close, I was thinking about Lilian Grisonas and Plan Condor, Uruguayan children that were taken through Argentina and then to Chile and abandoned there. We see sexual violence as a form of torture. We need to have initiatives that are specific to sexual torture and also children that were born as a result of sexual violation. They are victims too. We will always be liable here when we are looking at sexual violence. I believe we should do something like that. I am going to take a couple more minutes and I'll give the floor to the Executive Secretary and then the Rapporteur.
Muchas gracias, Presidenta. Yo seré muy...
Thank you very much, Madam President. I'm going to be very brief. I just have two ideas to put to you. First, we would like to thank the state for acknowledging civil society and the work that it's doing in order to look for the truth and instill memory and justice. When we were asked to hold this hearing, we thought this is the right time to hold this meeting. We had the 50-year anniversary, of course, but we also have an administration that recognizes events. We thought that this was the right time to hold a conversation, not only dealing with this public symbolic event, but also to remind the government of the inter-American principles that the Commission adopted in 2019 in connection with public policies related to truth, memory, and justice. When I hear the stage, when I see these women, I think that the state has conducted a series of actions that are not necessarily part of a policy of the state in the field of memory, truth, and justice. What the victims have asked us here is not something novel. They are asking for inter-American standards, which is to investigate the facts, to punish those responsible for the facts, and to provide redress. The rapporteur was talking about this, Commissioner Mantilla as well. They were talking about the fact that there is settled case law in this connection, and I think that we are now at a point in time where we cannot forget that there is backsliding in connection with memory, truth, and justice. And these discussions that we're having here with Chile, we need to use to move forward and to engage in a dialogue that is comprehensive in nature from the policy viewpoint. First, we need to have budget. Second, we need to have an independent monitoring system that involves the victims. And also, we need to have comprehensive action from the ministries and from the other independent agencies of the state. I would like to end by thanking the petitioners for having called this hearing. We think that this is an opportunity not to take a step back and to acknowledge everything you've done. Thank you to the government representatives for being here. Thank you very much, Rapporteur. Please be brief. I'll be very brief. Thank you very much, Madam President, Commissioner Caballero, Executive Secretary. Thank you to the victims' organizations for putting this issue on the agenda of the meetings of the Inter-American Human Rights Commission. I think the Inter-American system has historically worked on this and still has a lot of work to do in connection with violations of human rights that were perpetrated in Chile and in many other countries that were impacted negatively by the Condor operation. Thank you to Chile for the presentations made and the information that they shared with us. Also, it is very important to have in these hearings the presence of a representative of a member of the judiciary and to hear the commitment that the judiciary has in connection with meeting international standards. I have two very brief, quick questions. First, in connection with the public policies in the field of health and mental health, and also within the context of this idea of comprehensive reparation. The state recognizes that what was done so far is not enough and that efforts are being made to change that. But what is the specific plan that the state has in order to provide resources to give the appropriate response and that the state understands needs to be given? The government has indicated that it still has work to do, but I'm not sure what the specific plan is to do that. Secondly, and this is a question both for the applicant organizations and the state as well. Well, I would like to ask you to provide the Commission with investigation as to how you were investigating the benefits that the private sector entities got, for example, processes of privatization. Well, the economic actors that have been behind all this and that are not present here at this hearing. I think the state has investigated the matter, and I think victims' organizations also have looked into this and have raised the profile of these issues. Thank you very much. You have 10 minutes. Thank you very much. I would like to welcome the current rapporteur for Chile. This is the first time we see each other, and these issues are very important. Veronica de Negri is here with us, and Olga Westpiner is also here. Veronica de Negri is the mother of Rodrigo Rojas. He was burnt alive in the streets of Santiago, and she's here with a fourth of motherhood, and Olga is here. We have spoken today of flagship cases and his American brother that disappeared in 1975. Well, that case was time-barred by the Supreme Court of the United States, and time barring is still used in our countries, and the makeup of the Supreme Court really makes a difference. The presence of these two women, well, shows that they have fought for truth and justice before I was even born. My homage to them. So, the Foreign Office has indicated that it is a feminist Foreign Office, but there is no gender mainstreaming, I don't think, in their actions. We do recognize the presence of Justice Carroza. We have worked here for 20 years, and in the past 20 years, we have never had a member of the Supreme Court present at these hearings. We recognize the work done by the justice, and he was the first judge to include in his decisions the issue of sexual violence. So we depend on who the judge is. Also, we need to make sure that we know how judges are chosen in Chile, and that gender mainstreaming is included in that choice. And, for example, the judiciary this year had a hearing on justice, truth, and memory. And they invited the police and they invited other people, but they did not invite us. And we are the ones who know how difficult it is to deal with these issues and how difficult it is for us to have access to judges. We recognize that there is a human rights program, and the human rights program actually includes us. It is important for the human rights program to include in the meetings the victims of torture and of repression. In connection with the importance of looking at denialism, and that is a great challenge in our region. 50 years ago, the executive secretary of the Commission in October 1973 visited Chile, and we're sorry that the Commission has not made a statement in connection with the importance of this visit. This visit shows that there is denialism. 50 years ago, the Commission was the first authority to visit Japan, and we have two women here, Erika Hennings and Veronica de Negri. During the dictatorship, these two women submitted their cases to the Commission in connection with the killings of their most loved family members. Those cases, their perpetrators are still unpunished, and sexual cases were presented to the Commission. Those cases were archived. So we know that there is this discrimination against women in international organizations. We have also family members of very poor areas that live in very poor areas in Chile, and that they're the family members of disappeared individuals, and we're still waiting for the Commission to deal with the cases put by them. For example, the Quillota case. 2 of the women already died waiting for the resolution of the case, Ms. Lidia Raya and Ms. Tejada. And these people were on the waiting list. They died on the waiting list of the Comprehensive Health Program, the PRICE. So also I want to say that 50 years is not a time to just celebrate, and it's a time to become accountable, to render accounts, not only on the part of Chile, but also on the part of the Commission. The victims deposited their trust on these agencies and these bodies, and we are talking about transgenerational matters. So we have seen for 20 years no movement in the system. After years, and it's after a year that the state sent its observations, these women died. And there were a number of things that were not granted. These women died waiting for their cases to be heard. The Undersecretary of International Relations actually met with her before she died, and one of these women. This is the time for the rendering of accounts because of this excessive backlog in the investigations and the excessive delays as well in the investigations. We asked the Commission to confront denialism and to deal with cases that were originated in the dictatorship. And we have a number of denunciations vis-à-vis the state of Chile. Forced disappearance is persistent in Chile, and there is also cover-up of these actions. The armed forces have covered up these events. No mention was made by Chile of this. They have said that the National Police has a Department of Human Rights. So we continue to understand that the judges have had problems in accessing the files, and it is important to take into account the Inter-American Convention on Forced Disappearance. So the Supreme Court ruling is absent, and some other discourses are absent. The search plan of Chile is also absent. We're talking about forced disappearance. Forced disappearance is not a crime in our criminal code, and that's important. There is no appropriate treatment vis-a-vis the victims, on the victims that go to the comprehensive health programs. Mr. Ramirez disappeared in the Condor operation in Argentina. His remains were found in 2001. The medical legal service found those remains, and the sister, the mother of the victim, had already died without knowing that her son was there a few blocks away from her house, or its remains were there. And Ms. Olga is here. It is not possible for a government to still apply time barring in a criminal case like this. This is denying and refuting the Forced Disappearance Convention. Ms. Marisol Vega had been recognized as a victim, and she had been provided redress in the first and second instance, but that redress was taken away from her by the Supreme Court. So there are evidentiary mechanisms that are lacking. So we need to deal with this denialism. So this criminal time-barring case, we have been dealing with a time-barring case in the criminal courts for a year and a half. The argument by Chile is that they do not have to comply with legislative recommendations because this does not apply, but Olga is here to say that in the case of her brother, there is full impunity, and we have put this to the Commission for many, many years. The truth commissions have ended their work, so the government is saying that the convention does not apply, but we reiterate that we have a system that needs to be established, and civil society had called into question the appointment of the justice that wrote that time-barring ruling. That is all I have to say. I would like to thank the family members here present today, and also I would like to thank them for letting us represent them and for being their voice vis-a-vis this commission. They're great human rights defenders, and they're women. Now, you have 9 minutes because you used 1 more minute during your first presentation. Thank you very much, Madam President. Thank you very much for this conversation. Of course, we have moved forward as well. We had made progress, but there are things that we still need to be done. That still need to be done. Tomas Pascual from the Foreign Office is going to take the floor. He heads the Office of Human Rights. Thank you very much, Ambassador. Thank you very much, members of the Commission, and greetings to the civil society organizations that have asked for this public hearing. The Commission asked a number of questions, and the civil society organizations also put some things to us. A government can take on some commitments, and mention was made of the rendering of accounts, and the civil society organizations representative talked about this. Starting in March 2022 onwards, the government has tried to overcome this chronic delay that it had vis-a-vis the inter-American system. It asked the Commission to prioritize a number of cases from the time of the dictatorship in connection with the criminal time barring, the civil time barring, and the application of the decree of amnesty. In connection with all these matters, we have addressed 75 cases starting in March 2022, 67 of merits and 8 of unadmissibility. This in connection with Articles 8 and 25, in connection with the lack of civil reparations or the lack of investigation or the application of measures for time barring. We are still awaiting a case to be decided by the Inter-American Court that deals with measures of time barring. So, on behalf of the state, we do not want to put any obstacles in connection with the processing of these cases. The government, of course, doesn't have the financial capacity to, of course, do everything that it wants to do. In some instances, we are trying to try and provide redress to the victims in a dignified manner. We are trying to overcome these difficulties, and we also take on the call from the petitioners to include them in all these discussions, considering that the victims and victim representatives are the ones that are submitting these cases. We are trying to establish an internal mechanism for friendly settlements, and we're trying to provide opportune redress during our administration to the victims of the more than 100 cases that we have here in the Inter-American system related to military dictatorship actions. A number of issues were raised in connection with legislative matters. Daniela may perhaps deal with them, and Justice Carroza may talk about this, but as to how the state is looking at its concerns from a cross-cutting manner, in the Universal Periodic Review, and of course the Human Rights Commissioner is here, we know that there are recommendations for the investigation and punishment for the responsible for grave violations of human rights. So we know that there are some countries where extradition is delayed, or some countries do not have the possibility of extraditing individuals that have left Chile, and then they have been held responsible for grave violations of human rights. We have moved forward in connection with some aspects, and we do share with some of the things said by the civil society organization representatives, and I know that we are being listened to remotely, but the important thing is that the state of Chile has a historical debt in order to redress these crimes. Anything that we can do, it comes late. We cannot be opportune in a redress, but we're going to make every effort for this to be done as best we can. In connection with the consultations and the incorporation of gender mainstreaming in our actions, there are two initiatives that need to be mentioned. The Ministry of Women with the Subway of Santiago had a photographic exhibit in Plaza de Armas when we're trying to raise profile of the role that women have had in these situations. The idea is to create memory and this exhibit was included in the one of the torture centers in the street of Iran 3037, and this is the first time that an expropriation law is applied for these purposes. What we are doing is we're exploring certain avenues in order to be able to move in that direction. As the rapporteur was saying, we are aware of the fact that we need a policy of memory that brings together all of these aspects. One of the laws that was passed in the past 50 years is the law on sites and memory. We want to have a draft law as well that is greater in connection with memory, and we are going to include in due time civil society organizations in these efforts. One of the legislative commitments that we have is to classify as a crime forced disappearance, and this is a debt that we have vis-a-vis civil society. Also, we want to lift the secret nature of the valid report so that all the background information may be made known by the members of the judiciary, and we also want that to be a positive input to the search plan. More than answering the questions posed, I wanted to say that I have heard the concerns raised by the Commission and the civil society organization representatives. My commitment to you personally and institutionally from the judiciary as a whole, not only from the Supreme Court, well, as to all the matters that you have raised, as to whether the judiciary may be able to conduct these investigations in the future or not, and also the delays that have transpired, and also the issue of sexual political violence. All these things need to be addressed. We need to train people in these connections So more than anything, I wanted to make a commitment to you in the sense that everything that we've done so far is insufficient. But how can we not delve into what has happened in the past and what was not done, but rather move forward? We do have the search plan. We do have the police. We do have problems because of the loss of evidence. Fine, those are problems, but we need to try and agree and hold meetings. You know that I have a consistent relationship with you. Let's make that active. I am a member of the government, but of course, we can also liaise, you and I. That is my commitment to you, and that I wanted to share with you in the few minutes that I was given. Thank you very much to the state. I have a few comments. I'm going to take 1 minute from the technical team. I'm trying to respect the time or give the floor to you. I'm a Democrat, so I'm going to give the floor to people. This is not an easy dialogue because it has been a delayed dialogue. It is not easy then, but we have resumed this dialogue. So, Mr. Judge, we value your participation here. We also value the participation of the civil society organizations. We express our solidarity to you. We will continue to support you. This hearing is recorded and such. We know that the Commission has many mechanisms. A hearing is one of the mechanisms to deal with these issues. We know that these meetings are used for specific purposes. I'm sure that the rapporteur took due note of all these matters. So we're going to have a working meeting to look at the country agenda. That is another mechanism we have. Thank you very much again. I think the judge was saying that this can be a space to hold meetings. What was not done was not done. There is a debt. That debt cannot be paid, but one can take steps to try to build consensus. We have to fight against denialism. Truth and justice always has the face of women. This is the end of this hearing, which is adjourned.
Muy buenos días a todos y todas.
Well, a very good morning to each of you. I am very pleased to welcome the representation here of the presumed victims and also to the distinguished delegation of the United States. And with this, I hereby declare open case 14,543, Mustafa Sayed Hesse and others against the United States. And I am going to give the floor to Jorge Mesa, the Assistant Executive Secretary, for him to give us a few additional points on the case. Thank you, Madam Vice President, and good morning to you and to all. This case relates to the presumed responsibility of the United States for alleged arbitrary detention of those who are bringing the case, Mustafa Sayed Mehmedi, Mohammad Reza Mehmedi, et al., for violations of due process, freedom of expression, recognition of legal personhood, and their rights under the U.S. Constitution. 21 April of 2021 is the date to be considered here, and the 21st of October presented on the 29th of July. The speaker is going at the speed of light. The interpreter is doing the best she can. The point here, speed of light. You know, sorry. I was saying, to end, that the present hearing here is meant to hear the statements of the alleged victims and to hear any response. Thank you very much. The chair. We will first hear the alleged victim, and forgive my pronunciation, Mustafa Sayed Mehmedi, that the petitioners are presenting. The witness will share with us his experience under detention and alleged infringement of his freedom of expression and due process and alleged violations of human rights, as well as the reparations that he would consider appropriate given the alleged circumstances. Petitioners will have 10 minutes to conduct this questionnaire, and the state will, for its part, have another 10 minutes to also question the alleged victim. And finally, we shall, all of us, pose questions to the person making this declaration. Please, sir, tell us your full name, where you were born, and where you live.
Thank you. Good morning. My name is Mohsen Sayed Mehmedi. I was born in Iran, and I live in the United States, California.
Vamos a dar entonces inicio al interrogatorio.
We now open the question and answer section for 10 minutes.
The Commissioners, good morning to the Executive Secretary of the Inter-American Commission of Human Rights, the USA government delegation, and those present in this hearing. I'm Paula Angarita, and I'm going to do the questions. Mohsen, what were the reasons that you decided to move to the United States?
I believe in freedom and democracy, and the reason I came here is that we had a lot of problems in my country. My parents were against the government. We we were subjected to persecution over there. One of my brothers, Mushtaba, he was in prison in Iran for over 3 years because he attended a demonstration against the Iranian government. It was a peaceful demonstration for freedom and democracy. There was a crackdown on all the political groups at that time. My brother, he was tortured. We were all subject to investigation and inspection and harassment. Our house was raided at least a couple of times by the U.S. By Iranian government. I did not go to any political. I did not go to the war. I didn't join the army. I was against war with Iraq, and I wanted peace for my country. They took me. They didn't let me to get to university, so I had no chance for education. For all these reasons, also I could not speak my thought. I was getting suffocated in my country because of all that. We didn't really feel safe. Also, something else I should tell you that Revolutionary Guards. We had some Revolutionary Guards in my street. They were always harassing us. They used to write anti-American, like "Death to America" slogans in the wall of our house. They knew that one of my brothers was in U.S., so they felt that we are pro-Western and pro-U.S. They used to say they used to write "Death to anti-revolution." So we were all subject to humiliation and everything else. So that's why after the war ended, I joined the army. I got my passport and I got out of the country. I was not feeling safe and I could not even breathe there anymore.
Did you participate in any freedom of expression or speech once here? Did you advocate for democracy in Iran here?
Yes, I mean that was my whole intention, was to get here to be able to talk and speak my idea and for freedom and democracy, and it was my absolute right, which is protected under First Amendment, to get here. And I feel, even though I left my country, I felt for my compatriot back home. And I wanted them to be free. I felt that I can be a voice of my own people. That's why I attended a couple of demonstrations here in U.S., which was permitted and legal. And I will do, if I have to, I will do. It's absolute my right to practice my First Amendment right here.
What happened when you were detained in 2001?
Let me just go back a little bit. In 1999, we were arrested the first time. An immigration violation. My fake attorney was arrested and he was sentenced. After 6 months, we got released without any due process. We got released with high bonds, which is unusual because we didn't do anything wrong ourselves. And we don't have any criminal history or record. After 2001, unfortunately, that tragedy of September 11 happened. That was very heartbreaking for everybody. And I didn't know that I can be a casualty of post 9/11 myself. I'm a victim of 9/11 myself. I mean, the other casualties. I was going to my office. A white Ford car was following me, and I felt that somebody is following me. So they did stop me, and it was there were some FBI agents. They took me. They asked me to get out. They asked me if do you have weapon, ammunition? I said no, I'm a peaceful person. What's going on? They said you're getting arrested. I said why? I had my bond. I was going to my immigration courts. I have a valid work permit. I have no violation. They said, no, you're a terrorist. We have to take you. So they took me to their car, and I remember they asked me about my brother, Mustafa, and I told him that he doesn't live with me. They said, no, let's go to your home. They took me to my home, and when we arrived, they put a shotgun on my head, and they said that ask your brother to get out. I told him he doesn't live with me. Go ahead, ask him to get out. We know he is here. So I was shouting and yelling at my brother. I mean, he was not there. I knew that Mustafa, please get out. They're gonna kill you. If you don't get out, they're gonna kill you. And meanwhile, I had a shotgun on my head, and it was very scary and horrible experience. So anyway, there was no answer. So they said they want to. So anyway, I opened the door, and they got in. They searched the house. No, there was nobody. They searched even the garage. They did, and he was not there. So anyway, I was taken to custody, and I spent 41 months in detention, 20 months in solitary confinement in Santa Ana jail, about a month with all gangbangers and criminals in county jail in Las Vegas, and about 20 months in San Pedro jail.
What were the conditions, and did you have access to legal or medical service?
The condition was, I mean, horrible. First of all, you have they arrest 4 brothers, and every day you are seeing your brothers suffering, and you are suffering with them too. It is the hardest thing to see your brothers are getting harassed, intimidated, or even beaten, and you cannot do anything. My brother Muhammad, he was beaten by immigration officer right in front of all cellmates and us, and we couldn't do anything. And another brother of mine, Mustafa, he had a panic attack, and he was begging and banging the door, please let me out. And they didn't. Finally they did, and they took him, instead of taking him to medical, they took him to another cell, a cold cell down there. My other brother, my brother Muhammad, again, he was beat. He had, and he also had panic attack because one of his cellie, he was a suicidal guy. He cut himself, and the blood was all over. All over the cell, and he was banging the door. Please let me out. This guy is killing himself. And finally, and he was shaking. He was really badly shaking, and they didn't do much for him either. The food was bad, especially in Santa Ana jail. It was horrible food. It was spoiled food. Everything was expired, and it was the lowest quality food I had ever seen. And sometimes we threw away the food in trash. We had I would say, medical, no medical access, really, not much. I lost my teeth there. I had depression. We all had depression. We got PTSD. The access to lawyers were difficult. The conversation with the lawyers were getting recorded, and especially in Santa Ana jail, I know they did that. And sometimes they didn't give us our documents to be prepared for the court because they wouldn't let us to have it on time. So for all these reasons, we didn't feel comfortable at all. It was horrible. I couldn't talk to my parents. It was for some months. It was so hard to get to talk to my parents, and it was very difficult for us the whole condition.
Thank you, Mohsen. President, I would like to ask you for a few minutes to finish my questions. Just 1 minute. We only have one question left.
Un minuto.
Thanks.
1 minute.
Question, Mohsen. When you were released, were you permitted to remain in the United States? What has your life been like since?
I got withholding of removal, so I can stay here. We had to go to doctor, psychiatrist, psychologist for over 2 years myself. I had no money. My reputation is all gone. I lost a lot of friends, clients, and even it's hard for me to date because my name is shows on Google search as a terrorist, and it has to be cleared. So it's very tough for us altogether.
Thank you so much.
Thank you very much.
Muchas gracias.
Thank you very much. I'd like to make a correction. I identified the first party by the wrong name. Mossad is the person who is now testifying. That's correct, yes? Just so that I have that clear, because I'm afraid I might have used his brother's name by mistake. My apologies. I'd like to ask the U.S. government whether it has a statement or questions for the party testifying. No? In that case, we will continue with the statements from the second declarant.
Mustafa.
La pregunta de la comisión, por eso decía.
Any questions from the Commission? Because perhaps it's best to have the questions posed immediately before calling the next person. So we'll follow the following order. Second Vice President Roberta Clark, do you have any questions?
Much, Vice President Esmeralda. Just a few questions. You talked about you were detained for 41 months.
Yes.
And can you give us the details of detention of your three brothers? And were they all held in the same facilities that you were held in?
Yes, ma'am. We all, most of the time, we were together in the same facility. All of us, we stayed in solitary confinement in Santa Ana jail for 20 months. 24 hours of lockdown. Only 1 or 2 hours they would let us to go out. I mean, for free time, 1 hour, 2 hours. Sometimes I remember at sometimes even to 48 hours lockdown. In Santa Ana, and in Vegas also we were together. We all with criminals, gangbangers and everything else. And I was beaten up by a gangbanger in Santa Ana, in Las Vegas County Jail. And about 20 months also in San Pedro facility. Yes.
Yes, I just have two short questions.
Sure.
Were you given the reasons for your detention? That's one question. And the other question, what is your profession now? What was your profession then, and what is your profession now?
I've been a real estate agent since 1993. So it's my continuous profession since then. The reason for detention was I participated and my brothers also in some rallies against Iranian government, not U.S. government. It was pro-democratic rally for freedom of my country and my people. Basically, what the government says is that this is the whole core of their arguments in all proceeding is that participation in the rally creates material support, and that's why it caused it makes you to be a member of that organization, and thus you are a terrorist, and they equal participation in a free democratic rally to terrorism, which is I believe this is against fundamental rights of everybody. And I came to United States when I see that Lady Liberty up there, for me, it has a big meaning. It means that it means justice, it means freedom, it means law, and it means democracy. So that's why I came here, and I cannot believe that I got detained in U.S. for almost 4 years, 6 months the first time, and 3.5 years the second time. And my other brother, one of my brothers, he got detained 1.5 years the first time, and 3.5 years the second time. Like 5 years of his life, and we almost 4 years, because we just went to a rally against the Iranian government. The violation, immigration violation that they brought it up, it was just an excuse for any immigration violation. I had seen people, a family. Let me tell you this is a very interesting case. A family of 3, husband, wife, and daughter. All of them, they got married, fake marriages. All of them, they got detained in immigration court. In a month, all of them, they got freed. I didn't even see the judge to present my case. I didn't falsify any information. My lawyer did falsify the information. They signed the falsified documents, not me. I didn't even have a fair hearing. And after our arrest, intimidation of our witness was intimidated. The government told us that you guys have FBI agent. Told us that, Your Honor, I want them to get detained. For them, it's safer to be here, because other people, I don't know, some people want to kill them, and I want them to cooperate with me. And that was the condition of the release, was for us to cooperate with him and probably become informant. And we did not want to cooperate because the groups or the organizations who are pro-democratic against the Iranian government, we share the same values. I cannot lose my integrity and conscience.
Sí, vamos para tener la oportunidad de la participación.
Pardon the interruption, but we do want to have the opportunity for other commissioners to phrase their questions. Commissioner Mantilla.
I hear your story with very attention, and I have like a few questions. According to your story, you were expressing yourself, and because of that expression in this March, you were detained. So after you were released, did you ever participate in any other protest or march? This is first. Did you ever express? And the second thing is that it's hard to talk about reparation, I know, but if you could think about any way of reparation that you think that you deserve, what would you expect as a reparation? So these two things, please. Thank you.
Thank you. Sure. Yes, I did. As I mentioned, it is my absolute right to go to any demonstration, and I'm an advocate of freedom and democracy in my country. I did the last couple of demonstrations I went. It was in Los Angeles. It was for the life. For a lot of Iranians, they came to LA because we have a kind of semi-revolution. They had a semi-revolution last year in Iran. What they call the Woman Life Freedom movement. So I did. And I will do. If there is any more demonstrations, absolutely I will. And if they cannot arrest me, they should not arrest me anymore. I mean, it's so ridiculous that they take you they take your freedom because you want other people to be free. They take your freedom in USA. My request, genuinely, we have asked before through our lawyers, is our reputation is gone. I mean, the defamation was big. I mean, for me, even dating is difficult because people or even getting clients is difficult. They Google your name easily, and they see you as a terrorist. What's going on? I want U.S. to give me an apology, a written apology. I heard somebody giving me a verbal apology, but that's not enough. It doesn't solve my problem. I didn't hurt you guys. You hurt me. And second, I didn't have a fair hearing. My status is, I don't have any status, good status. It's the withholding of removal. Anytime the government change, I cannot do much here. I want a fair hearing. I want an adjustment of status. Also, I need them to offer a remedy for me. I lost 4 years of my life here, combined with my brothers. Over 14, 15, 16 years of life is lost. Useful youth life.
Gracias, comisionada. Comisionada.
Thank you, Commissioner Caballero.
Thank you very much.
Thank you.
I don't know how clear this. What is your immigration status right now, and if you have been involved in a conflict with the state about this point recently? These two questions.
What was your second question? I'm sorry.
The second question is if you have involved in a conflict with the states about your immigration status, specifically.
You mean contact with other states?
No, with the states, with the United States, with the state.
Oh, I see. I'm sorry. My status is withholding of removal. It means that they cannot deport me. I'm deportable under their law, but I cannot stay here for long. I mean, I don't have green card. I don't have anything on hand. And also, I got protection under CAT, Convention Against Torture. It means that if I get to Iran, I can get tortured. So I don't really have a solid status. I cannot go out of my country. I lost my parents 4 or 5 years ago, and I couldn't see them. I didn't see my parents for 25 years. I wanted to be with my parents when they die. I wanted to see them, meet them, kiss them, hug them. I couldn't. My dad passed away. I wanted, honestly, my brothers are here. I seriously wanted my dad to die in my own hand, not even in hospital, in my lab. Or my mom, same. My mom was my friend. I lost my mom 4 years ago, and she didn't meet us. My older brother, he's been here for 40 years. They didn't for 42 years. They didn't see each other. We cannot go out. We could not go to my mom and dad several times. They asked us why. Go talk to a lawyer, do something. I can't do much, Mom. I cannot go out of the country. Can we see you in Turkey? Can we see in Spain, France? No, I can't. Why? And my dad, when we got released, let me tell you this. They asked me, my dad, when I told him that I'm for 3.5 years, they didn't know we are in detention. We didn't tell them. 4 brothers. They took 4 brothers together to break him down. They wanted us to cooperate for what? To cooperate against other freedom seekers that we share the same values. So I don't have any status. I lost my parents without seeing them. I just sometimes some of my friends they send me a picture of their graves. That's it. And U.S. has not helped us so far. I mean, we are under probation, sir. We have been under probation for 15, 17, 18 years. We had to call them weekly after we got out, even though we are not criminal. We had to call them weekly to say that we are here for probation. The officers, they used to come to our home once a month, and then it becomes 6 months. Even now, up to now, once a year we have to go and report that we are here. We are not escaping. Where can I go? I need a status. I don't have any status. I lost a lot of money. I lost all my reputation, 4 years of life. And I hope it doesn't happen to other people. I hope so. And the material support, that this word that they could use in their immigration status, immigration arguments, material support, attending a rally is a material support for this organization. This organization had over 200 congressmen and senators. They supported them. Mr. John Ashcroft, he was supporting the organization. We were arrested at the time We were arrested at the time that Mr. John Ashcroft, he was head of Justice Department, and he was supporting that organization.
Yes. Thank you very much. I appreciate your answer. We have to finish. Thank you very much.
Gracias, disculpe.
Thank you. Apologies. Thank you very much. I will not pose any questions in the interest of time. Thank you to the declarant for his testimony. Now we will call upon the second declarant, wait, do I have it right now? See, I had the order backward. Mustafa Sayed. Thank you.
Y ahora sí. Muy bien. Disculpe, sí. Vamos entonces a escuchar al...
We will now hear from this presumed victim, Mustafa Sayed, who will testify as to his experience in detention, the alleged violations of freedom of expression and due process, the impact thereof on his life as a result of these human rights violations, and the reparations that he deems necessary. The petitioner will have 10 minutes for questioning. We do ask that the declarant be precise in the interest of time so that the Commission and the government will have an opportunity for questioning as well.
Mustafa, did you participate in any freedom of expression or speech once here in the United States?
Yes, I have. I have been in several rallies, pro-democracy rallies sponsored by NCRI in this country, including the one in Denver in 1997.
Thank you. What happened when you were detained in 2001?
In 2001, I received a phone call from my attorney that you should give in to FBI, and FBI is looking for you. They want to detain you again. And I gave my address and everything, and they came there with all guns and everything on my head, as usual. It's normal for them, I guess. And they arrested me and detained me, and they took me to downtown for processing. And at that time, they put me in a room that was about 20 feet by 15 feet. There were about 150 people there, and there were 2 toilets there. One was always clogged, and it smells all over this. And we were begging the guard to open the door and let us have some air. They would not even do that. So they used to keep us there for all day, and at night time they take us to San Pedro jail. And San Pedro jail, there were no bed at the time. They didn't have a bed, so they had some plastic temporary beds. They put those in restrooms, in the toilets, and they asked us to go and sleep there, and we used to sleep there, and the next day they used to do the same thing, going to downtown again and being in that same room again. So this was going on for some times, and after that we actually went transferred to Santa Ana jail. It's a different jail, and we were there for some times, for a long time. And in that particular jail, each cell there were 2 beds on each cell, and we were locked on most of the time. I mean, 24 hours, and sometimes for 3-4 days even we were locked down, and we were begging to be out for an hour or two, and sometimes they would let us out for an hour or two. But beside that, it was really hellish life for us. It was so stressful, and we went through so much stress and everything. Basically, that was that jail, and at some point they took us to Las Vegas jail as well, and in Las Vegas jails, it was really bad. All gang members, killers, and bank robbers, and all those people were there. And so we were basically mixed with criminals all the time. In all these three jails, they all were rapists, criminals, bad people. I do recall in San Pedro jail, I asked that I didn't want to sleep next to a gang member. They said, no, you cannot do that. You have to sleep right here. And then I said, I don't feel comfortable. These are gang members. These are killers. I just don't feel safe. And they told me that you have to do. I said, is there any way that I can go to segregation? They said, no, you have to do something bad in order to go there. I said, what should I do? I said, well, you have to go and beat somebody. So in order to go to basically to segregation, I thought is safer personally for my life. They said, no, you cannot do that. You have to be this and that. And the situation was very bad. I personally am vegetarian, and I lost at least 20-some pounds while I was in jail, and they were not giving the right food to us. And also one side of our story was my mom and dad back home in my country. We used to call them once every 2 weeks, and when we were detained, they didn't give us the chance to call them for at least 2 months or so. And my mom was thought that something has happened to us, and basically she went to hospital and she was in a really bad shape. So we were dealing with our folks back home, our life here in jail, and meanwhile we used to pay our bills and all these things on time. We were trying to pay all these things as well.
Thank you. When you were released, were you permitted to remain in the United States?
I had a temporary status. We all had a temporary status under Convention Against Torture, CAT. Yes, we could stay as long as government of Iran was back home, was in existence. Yes, we could stay here. Yes.
Did you have a fair hearing in the immigration proceeding regarding the revocation of the bond and the grant of asylum?
Yes, our bond revocation, it did happen when we had a bond hearing. We didn't have a fair hearing. All four of us were bundled in one hearing, and so it was not an individual hearing for our bond. So, and FBI agent Castillo, he produced a document, and our name was there, and he called this LSL form, and he said that this shows that you guys are a member of a terrorist organization, basically, and he asked the judge to not to give us bond and keep us in jail as long as possible, because he was asking us to cooperate with him on a case that he had against some people that were against government of my country, basically, and yeah, and he also said that attending a rally creates material support for that group. Attending a rally create material support for that group.
Thank you. What has your life been like since?
When we got out of jail, it was hell, really. Our life was completely upside down. We were drained, psychologically destroyed. We used to go at least for 3 years to different psychologists and doctors, and also we lost. I mean, everything was expired. My real estate license was expired. My DMV IDs were expired, and we had to go through all these things and renew everything. And when I got in touch with my clients, they all were very afraid. They all were very afraid to talk to me. They said that you're a terrorist. They say we don't feel comfortable. So they really destroyed our life. Our life was completely destroyed by U.S. government for 3.5 years. A stressful life, a stressful day, night, thinking what's going on, what should we do with my mom and my dad, what the heck to do this here, because we didn't let my parents know that we were in jail all along.
We finished. Thank you.
Muchísimas gracias.
Thank you very much indeed to you who have made these statements. And let me state that, of course, there is, as we know, the right of the state to reserve its right to withhold any interrogation. But as you did with the first person, I'd like to know where you stand on that point here.
Any questions at this time? Thank you.
Bueno, no, muchísimas gracias.
Thanks so much. Note taken. Roberta, go ahead. It's all yours. We'll give you the floor. We're giving the floor to the Commissioner Roberta.
Short question. You said, sir, as you began your testimony, you said that you were detained again in 2001. Were you detained before that?
Yes, we all were detained the first time in March of 1999, and I do recall that a special agent and the FBI agent, they both told us that they would send us to Iran as a present for President Khatami back home in my country. So they were trying to send us back home as a present to Khatami. So this clearly shows that our case was politically motivated since the inception of it. So and they also told us that they used word F. You are fucking mujahid, and you will be sent to Iran as a present to President Khatami, because it was a Persian. It actually was March is a Persian New Year, so they were trying to send us as a present to Khatami for the New Year, basically. And we actually were in detention in jail for 6 months, the same situation that I explained before, that they used to take us to these bunkers. They call it bunker. It's a room around 20 feet by 15 feet. And we were there, 150 people, sometimes 200 people were there. And no air, a smell everywhere. I mean, so they used to keep us there for weeks. And at night time, they used to take us to San Pedro jail. Again, the same problem. Bathrooms. They put us in bathroom. They with this bed that they had, and then the next day they used to take us again, and then at one point they kept us in San Pedro jail. And I'm sorry, we actually, the first time we were in Lancaster jail. We were in Lancaster jail for a long time. So we were detained for 6 months ourselves. Three of us. Muhammad was in jail for a year and a half. So and we had the same stressful life. And my parents, again, was the issue here. How should we get in touch with them? And so on.
Gracias, Commissioner.
Thank you. Commissioner Mantilla. Thank you.
Mustafa, thank you very much for your testimony. 2 short questions, please, to be very precise in the answer. First of all, you mentioned that you have this psychological impact, depression. And besides that, you have other impact in your physical health, that your body, your behavior change, and these things. And the other thing is that if you have the opportunity, I know that it's very difficult to talk about reparation after all what you suffer. So, but if you could ask for a reparation, what would you ask now? Thank you.
In regards to, I mean, I have some stuttering, as you can hear me, and this did happen in 1999. The first arrest that I had, and we all had, and the way they attacked our home, the way they acted toward us, banging our doors from back and forth through the back side and front side, dang, 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 open. It was about 5-6 a.m. and I woke up and I was fainted, and I was just about fainting, and they came inside with gun at our head. You are terrorists, this and that. Where is your guns and explosives? I said, we have no guns and explosive here. So, and then they search everywhere for guns and explosive and things like that. So from the beginning, from that point, I started studying, and my life really got upside down from that time. And life in jail, 3.5 years of precious life the second time, and 6 months of my precious life and our precious life the first time. There has to be a remedy for that. It's not fair to us. And we went to different courts in this country. We went to Ninth Circuit, to different courts here. They informed us that they could not hear our case because we are not a U.S. citizen. And beside that, they informed us that government has immunity in this country, and they can do anything they want, basically. So, in a way, they told us that government is absolute here. There's nobody can do anything about it. They are absolute. They are the king. The king, not like you. They're absolute. So basically, and for that, we would like to have a just remedy for what we have gone through in our life and so on. And as I don't know if Mohsen explained to you or not, we had a key witness in our immigration case that was threatened when he came to court. He was threatened not to be a witness, so he left. If he were to become a witness, he was told that he would be charged and put in jail again. So our key witness for asylum, he left the court, so and so on. Thank you.
Gracias.
Thank you. Commissioner Caballero and is passing, no questions here. So I would like to make two specific points. When you came to the United States, when you first got here and left your country for reasons of concern for your security, persecution, whatever the reasons might have been, what was the perception you had upon arriving in the United States? How did you see the country? How did you feel the country? What was the response that you were receiving from the United States upon seeking entry to the country? I wonder whether I'm being clear enough. What kind of welcome did you get here? What did you sense that welcome to be? Go ahead, sir.
Yes, ma'am. Actually, I came in this to this country in January of 1978. It was year before a revolution, and I came here as a student, and I did have a visa here. And while I was in this country, I did attend rallies against the mullahs that are in power right now. So I turned against them basically. But of course, in this country, I was very happy to be here, because I thought here we have it is center of the democracy and so on. So yeah, that's basically.
Thank you. And in that same line, following your thought, when you felt that United States was a place that was lawful, that stood for freedom, when did that begin to change in your mind? When in your life did you suddenly start to feel different from when you first came, given your image and what you knew of the United States then, but from what you know today of the position of the United States, having changed its position in terms of treatment and the entire set of descriptions that you have used? You talk about a real hell of sorts as you have came to feel. What made that change? How could you, or how do you explain that change in your perception of how the U.S. came to act, where when you first came here you felt, you know, everything was positive, and suddenly you might have said, well, I don't understand anymore. How did that change happen, and what sense did you make of it? Why do you think there was a change? What do you think changed the impression or the attitude of the state, of the government of the United States toward you? How did you see that truth, as you perceived it, change? I hope you got what I'm saying. Yes, Grant, thank you. Go ahead.
Yes, I mean, from the beginning, that's what I explained, that I was under the impression that this country is for democracy and everything, and we have these rights to attend rallies and read different books and different opinions, so and so. But what happened in our case was the one that changed my mind about it. What really happened in our case, it was, I just couldn't believe it, that this is going on in this country, and I'm sitting in jail, and they're asking me to cooperate, and they're asking me attending a rally creates material support and so on. So actually, it happened. The change happened. What happened to us basically changed my mind about this whole issue.
Bueno,
Thank you then very much. I want again to thank you for your statement, and we will now continue hearing the position of the two parties. The petitioners will have 15 minutes to put its case forward, and the state, of course, will follow suit if it so chooses. I give you the floor.
Members of the Secretariat, thank you for convening this hearing. Thank you as well for providing a space where Mohsen, Mojtaba, Mostafa, and Mohammed can finally be heard after years of being denied a hearing in the United States. The Mirmeti brothers are here today because of the enduring effects of the pervasive discrimination against non-citizen Muslim men of Middle Eastern, African, and South Asian descent post 9/11. And the systematic closing of courthouse doors to immigrants seeking to vindicate their rights through the judicial system. I will discuss how the brothers had their bond revoked after 9/11 based upon their political expression and ethnic origin. Then we will discuss how they were denied proper due process based on their immigration status. And then we will discuss the reparations the brothers seek. After 9/11, the United States government embarked on a massive investigative campaign. As a result of this campaign, the FBI arrested 738 non-citizens between September 11th, 2001 and August 6th, 2002, 97% of whom were Middle Eastern, South Asian, or of African descent. Nearly all of these detainees were found to have no connection to terror groups. The Mirmetis, who are in front of you today, were caught in this unjustified sweep. The Mirmetis came to America because of persecution for their political expression in Iran. In the United States, the Mirmetis became real estate agents in the greater Los Angeles area and continued expressing support for a democratic Iran. They saw America, as it is so often portrayed in the media, a beacon for the open expression of ideas, and understandably believed that they finally lived in a country where this expression would be protected. They attended several pro-democracy rallies during the mid-1990s, including a June 20th, 1997 demonstration in Denver, organized by the National Council of Resistance of Iran, the NCRI. While only 2 of the brothers were able to attend the rally, all 4 originally planned on attending. After 9/11, the Mirmetis were caught in a dragnet that primarily targeted Middle Eastern, South Asian, and African men. The government detained the brothers and sought to revoke their bond. The main piece of evidence used against them was a travel log for the 1997 Denver rally. The FBI took the log out of context, and it became the crucial piece of evidence used to revoke the brothers' bond and arbitrarily detain them for 3.5 years. The FBI argued this was not a travel log, but a cell form that demonstrated the Mirmetis were supporters of the MEK, an Iranian opposition group listed by the United States as a terror organization in 1997 and delisted in 2012. Dr. Mehran Kamrava, an expert in Farsi and regional politics, submitted an affidavit today for the hearing, confirming that the FBI mistranslated the form and it is simply a travel log. The date of the NCRI event even appears on the top of the form. In reality, the brothers were never members of the MEK and simply cared about promoting democracy and human rights in their country of origin. The U.S. detained the Mirmetis for 41 months, using evidence that only existed because of their political expression. The list of names, given that it is incontrovertibly related to attendance at a pro-democracy demonstration, implicates the brothers' rights to freedom of expression, assembly, and association. The U.S. violated the Mirmetis' Article 4 right to freedom of expression by revoking their bond based on evidence related to their political speech. The Commission's jurisprudence prohibits discrimination and detention based on freedom of expression. In Bisset v. Cuba, for example, The Commission found a violation of the petitioner's Article 4 rights when they were arrested for protected political speech. The United States' actions in this case are even more egregious than Bissett because the speech here was not even directed at the United States, and it was endorsed by members of Congress at the time, many of whom attended the rally in Denver in 1997. The Commission has also emphasized that the rights to freely assemble and associate are closely related to freedom of expression. In Huilca Texe v. Peru, the court found that the right to assemble and associate included the pursuit of a legitimate goal without pressure or interference from public authorities. The United States violated the Mirmedis' rights to assembly and association by detaining the brothers for participating in a peaceful assembly with fellow supporters of a legitimate political cause, democracy in Iran. 4 brothers escaped political persecution in their home country and learned that their human rights were still every bit as illusory in the United States. I'll now turn it over to my colleague, Kat Washington, to discuss the deprivations of due process that the Mirmedis suffered.
Thank you. As my colleague stated, the Mirmedi brothers have endured significant due process violations, largely stemming from discriminatory post-9/11 policies, the use of false evidence and testimony in their bond revocation hearing, and the denial of any effective judicial remedy. The American Declaration and Inter-American case law both prohibit discrimination and guarantee rights for all, even for non-citizens, and especially for protected political activity. In both Frere Missouri and Biscuit, the Commission found that a state cannot make distinctions in treatment that are disproportionate to state goals, or that are discriminatory. Both independent NGOs and the U.S. government have found that the United States post-9/11 immigration, national security, and anti-terrorism policies were based on discriminatory religious and racial profiling. The U.S. consistently denied the Mirmedis' rights under the same discriminatory framework. The timing of their arrest indicates that the U.S. used the LA cell form as a pretext for arresting them. In actuality, they were arrested due to their Iranian nationality, as part of a systematic profiling of Middle Eastern immigrants after 9/11, culminating in a denial of the brothers' rights under Articles 2 and 17. The brothers also endured violations of their right to an impartial hearing. In Mortlock v. U.S., the Commission recognized that an individual shall not be denied due process protections in immigration proceedings. In addition, in Oliveros Munoz v. Venezuela, the Commission established that a state's duty to fully and impartially investigate its human rights abuses is obligatory. It cannot be just a mere formality preordained to be ineffective. The U.S. utilized blatantly false and misconstrued evidence to justify the revocation of the brothers' bond, including the distortion and falsification of several aspects of the LA cell form. Moreover, the decision to revoke the brothers' bond was also tainted by witness intimidation. In Telugus v. U.S., this commission found that the use of witness statements known to be false amounts to a denial of justice, contrary to due process standards. Baran Tabatabai, a witness that corroborated the FBI's version of events, recanted his testimony on 2 separate occasions. Tabatabai was also prepared to testify in favor of the brothers during Mohammed's bond hearing, but Agent Castillo threatened him prior to this hearing. Castillo's threats persuaded Tabatabai not to testify. By basing their case against the petitioners on falsified evidence and recanted testimony, the United States violated the Mirmedis' right to due process and a fair trial. After release from detention, the brothers filed a civil rights lawsuit in the U.S. District Court, alleging false imprisonment, unlawful detention, witness intimidation, and conspiracy to violate civil rights. However, the District Court dismissed all of their claims. The Ninth Circuit Court of Appeals affirmed this dismissal on the grounds that non-citizens do not have an ability commensurate with that of citizens to seek justice for violations of their rights through the United States judicial system. The Court of Appeals also found that the brothers had an effective remedy in their immigration proceedings, despite the fact that it is not possible to bring a wrongful detention claim in U.S. immigration court. In Amezian v. U.S., this commission held that the denial of a remedy is an independent violation of due process rights, and that where a petitioner was unable to access any effective civil remedy for 16 years, every indication of domestic law is that such remedy is not meant to exist. The Commission also found that there is an inalienable right to know the truth about past events so as to prevent recurrence. Likewise, here, for over 20 years, the United States has systematically deprived the Mermetis of any effective judicial remedy for their wrongful arrest and detention. More fundamentally, the Mermetis have had no chance to expose the truth, motives, and circumstances behind their unfounded detention. We thank you today for providing Mustafa, Mohammed, Mohsen, and Moshtaba the chance to have their voices heard, an opportunity that they were denied in U.S. court. I will now turn the discussion to my colleague, Tessa Baser, to discuss the long-term consequences of the brothers' detention, along with what they hope to achieve by bringing this case.
Thank you. The petitioners have suffered consequences to their health, professional lives, and personal lives because of their arbitrary arrest and detention. Over 20 years after their initial arrest, the Mermetis have yet to receive reparations or compensation for their wrongful detention and the lack of due process that they endured. The Mermetis continue to suffer long-term mental health effects stemming from their detention, such as frequent nightmares. Mustafa has constant, recurrent traumatic memories. Mohammed has recurrent anxiety when he sees things that remind him of his wrongful detention, such as white vans and plastic silverware. He remains in constant fear of the FBI's watchful eye. He also re-experiences trauma whenever he has to interact with immigration officials, which is a necessary and regular occurrence due to his lack of permanent status. Mohsen also experiences recurrent fear and anxiety when seeing unfamiliar cars and people, and remains constantly nervous that he is being watched by government officials. Mujtaba experiences sudden flashbacks, anxiety, and depression. The brothers have adequately and aptly testified today as to the reputational harms they've suffered. They were unable to work for 3.5 years. After they were released, their client lists were decimated. As they've testified, the United States' false accusations continue to affect them to this day. These false accusations against them damaged their reputation in both Los Angeles and Iran, because they were widely publicized in both national and international media. In Amezian, this commission held that a remedy for a human rights violation must be sufficient to obtain reparation for the harms caused. In Maldonado Rodriguez, the commission held that states are required to provide integral reparations for human rights violations. We urge the commission to recommend that the Mermetis receive compensation, comprehensive reparations, and remediation for the violations they suffered as a result of state action. These reparations must include monetary compensation for the pain and suffering the Mermetis endured while detained, and the hardship the brothers incurred due to their combined loss of income, clients, and property. In Amezian, the Commission recommended that the petitioner, who was detained without charge due to alleged ties to terrorism, be compensated both for his wrongful detention and for the lasting psychological harm that the actions of state officials caused. In Suresh v. Canada, the Commission recommended that the state provide reparations to the petitioner who was wrongfully detained and denied permanent status because of the government's false belief of his involvement with foreign terrorism. In Amezian, the Commission also recommended that the state provide a public statement by a high-ranking official making clear that the petitioner is not and never was a terrorist. Here, reparations must include formal recognition of the state's wrongdoing through an official apology by high-level officials and the state officials who were involved in perpetrating these harms. The reparations should also include an adjustment of the Mermetis' immigration status to that of asylum. Due to the lack of due process they faced in the immigration proceedings, the brothers need to have the rights and stability coterminous with that of a more permanent immigration status. Reparations must also include the adoption of measures aimed at clarifying the facts of their arrest and detention. They have not yet had the chance to expose the motives and circumstances behind the state abuse. In Los Ventura v. U.S., the Commission urged the United States to review trials and sentences according to the fair trial and due process guarantees in the American Declaration. They should do the same here. This could include an investigation aimed at evaluating the facts of the petitioner's arbitrary arrest and detention according to inter-American standards. Finally, the United States must formally review its laws, policies, and practices to ensure that additional persons are not deprived of fundamental rights based on their immigration status or national origin. The U.S. should train its officials, including those in the judiciary, according to international standards. In Ferrer Mazorra, the Commission urged the United States to ensure all rights in the American Declaration be fully afforded to detained non-citizens. Distressingly, the Commission made this recommendation in 2000, before the Memeti's wrongful detention even occurred. To this day, the United States continues to violate the rights of non-citizens held in detention. The United States must take measures now to ensure the non-repetition of these violations.
Muchísimas gracias. Vamos inmediatamente.
Thank you very much. We now ask the state whether it wishes to exercise its right to make arguments.
Thank you first to the distinguished commissioners, Secretariat colleagues, to the Mermedi family for being here today, to the two brothers who shared your experiences. My name is Thomas Hastings. I'm honored to be here in my capacity as the Deputy Permanent Representative of the U.S. Mission to the Organization of American States. I'd first like to reiterate my government's support for the Commission's important work of monitoring human rights situations and shedding light on these issues both here in the United States and throughout the Western Hemisphere. We also acknowledge that petitioners before the Commission play an important role in advocating for the promotion and protection of human rights by all OAS member states. And to that end, we'd like to thank the petitioners who are participating today for sharing your testimony. As an initial matter, the United States maintains its position that this case is inadmissible before this body. However, we are here to listen to the petitioners on this matter and receive any observations which are raised in today's hearing by the Commission. I'm pleased to be joined here today by colleagues from the U.S. Department of State and the U.S. Department of Homeland Security who will provide further U.S. statements on this matter. And I'd like to first turn to my colleague Sarah Hunter from the Department of State's Office of Legal Advisor to begin.
Thank you. For context, I'll begin with a brief history. The petitioners arrived in the United States between the years of 1978 and 1993. For years, they lived and worked here without legal immigration status. Eventually, they all applied for asylum in 1998 with the assistance of an individual who was later convicted of filing false claims. Petitioners admitted that they filed fraudulent applications and obtained fraudulent identification. This included falsifying dates of entry to satisfy the general requirement that you apply for asylum within 1 year of arriving to the United States. In 1999, they were arrested for immigration violations but released on bond that same year. Their immigration case progressed, but in early 2001, the federal government searched an MEK safe house and uncovered a document containing the names of petitioners, the LA cell form. An FBI translator described this document as a list of affiliates of the MEK, then designated as a foreign terrorist organization by the U.S. Department of State. In light of this development, as well as testimony by an FBI agent who was in touch with a confidential informant and other information, the government revoked bond for the petitioners in October 2001. An immigration judge upheld the bond revocation. That decision was explicitly not based on the LA cell form alone. Petitioners filed habeas petitions regarding their detention, which were held by the Board of Immigration Appeals and the U.S. District Court. In 2002, they were granted withholding of removal, but denied asylum given the untimely filing date. Moshan and Mohammed appealed to the Court of Appeal, which remanded on the bond determination but upheld the asylum denial. Ultimately, all of the petitioners were released from detention before the district court rendered a decision. Petitioners also filed a civil tort claim. That claim was in part settled, and the remainder of that claim was dismissed. That dismissal was affirmed. What I hope to illustrate with this review is the due process the petitioners received. Their assertions were carefully considered in several forums. The United States reiterates that petitioners settled their civil case and received monetary compensation. That settlement precludes review here. Although petitioners may not be satisfied with the result, they have received effective remedies. They were given the chance to appeal various decisions, were ultimately granted withholding of removal, received monetary compensation, and released from detention. As both the Commission and the Inter-American Court have stated on numerous occasions, these international human rights bodies are set up to work as complements to domestic courts and processes. The Commission has explained that under the fourth instance formula, that it lacks jurisdictions to substitute its judgment for that of the national courts on matters that involve the interpretation and explanation of domestic law or the evaluation of the facts. To this end, the Commission's role is not to sit in review of domestic forums. The petitioners have had ample opportunity to make these claims and did so. As we stated in our briefs, petitioners have also failed to exhaust all available domestic remedies regarding their bond determinations and asylum claims. Accordingly, the United States urges the Commission to reconsider its admissibility decision, allowable under the plain reading of Article 34, which notes that not only petitions but cases may be found inadmissible. Petitioners are also unable to establish any violation of the American Declaration. The American Declaration recognizes an individual's ability to access judicial remedies, but it does not preordain the outcome of those remedies. That petitioners did not prevail in their challenge before U.S. administrative bodies and courts does not and cannot mean that they were denied access to judicial remedies under the meaning of Articles 18 and 26. Despite their contrary claims, they were not arbitrarily detained. They were detained because they violated immigration laws, and there was evidence connecting them to a group on the Foreign Terrorist Organization list. Their nationality and political activity were not factors in their detention. Their potential relationship with a terrorist organization was. The petitioners re-raise arguments they made domestically about the allegedly falsified evidence that led to their bond being revoked. Multiple administrative bodies and courts heard this evidence. And their brief is replete with claims that the government agents involved in the case knowingly presented false information, but they have presented no facts to substantiate that claim then or now. Moreover, Article 33 of the Declaration recognizes that the duty of every person to obey the law and other legitimate commands of the authorities of his country and those of the country in which he may be. Non-nationals are bound to respect the state's immigration laws and may be subject to various measures, including detention, as appropriate when they fail to obey the law. Immigration detention, provided it is employed in a manner consistent with the state's international human rights obligation, is permitted under international law. Overall, petitioners have failed to establish facts to support any violation of the American Declaration. Finally, the United States has consistently maintained that the Commission's recommendations are not binding on the United States. The expansive relief that petitioners request goes far beyond the Commission's remedial capabilities. Let me now turn to our colleagues from the U.S. Department of Homeland Security for their statements.
Distinguished commissioners, petitioners, representatives, secretariat staff, and colleagues, on behalf of the Department of Homeland Security, or DHS, I welcome the opportunity to participate in today's hearing. My name is Scott Schuchart. I'm counselor to the director at U.S. Immigration and Customs Enforcement, or ICE, which is a component within DHS. First, I want to share with the Commission that the DHS Office of Inspector General, OIG, and the DHS Office for Civil Rights and Civil Liberties, CRCL, as well as the ICE Office of Professional Responsibility, OPR, all reviewed allegations that Mohammed Mirmeti was mistreated by an ICE detention officer in ICE custody on March 5th, 2005. And as was shared with him in a letter from CRCL dated March 27th of 2008, the OIG's independent investigation, which included interviewing multiple witnesses, did not substantiate those allegations. Following the incident, ICE also notified both the Civil Rights Section of the United States Attorney's Office in Los Angeles and the Civil Rights Division of the U.S. Department of Justice about the incident, and both declined to prosecute. Second, I want to discuss ICE detention and bond proceedings. Prior to obtaining a final order of removal, ICE detains individuals where ICE is prohibited by law from releasing them, or where the facts of the case reflect that the individual poses a danger to persons or property, or where it's determined that no amount of bond or conditions would be sufficient to ensure the individual's appearance at future immigration proceedings or for removal. As happened in the petitioner's case, non-citizens may challenge a determination of whether they are bond eligible, and an adverse bond decision by an immigration judge may be appealed to the Board of Immigration Appeals. The federal district courts also have jurisdiction to consider challenges to prolonged civil immigration detention in the context of a petition for writ of habeas corpus. Finally, I want to highlight ICE's current detention standards, which are designed to ensure that non-citizens in ICE's custody are treated humanely and with respect, protected from harm, provided access to necessary medical and mental health care, and able to access materials and individuals who may represent them or assist them with their immigration cases. ICE has updated and revised its detention standards since the petitioner's period of detention. For example, ICE's performance-based national detention standards, first issued in 2008, were most recently revised in 2016, and the separate national detention standards, which apply to certain facilities, were first issued in 2000 and revised most recently in 2019. ICE's detention standards now establish minimum conditions of detention for detained non-citizens with respect to environmental health and safety, detainee non-citizen care, access to legal resources and consular officials, recreation activities, grievance processes to address complaints and concerns about conditions of confinement, and a number of other issues. These standards are designed to ensure humane conditions tailored to the needs of the ICE detained non-citizen population, consistent with the civil rather than penal purpose of immigration detention. And now I will turn it over to my colleague Monica Burke to talk about detention oversight.
Distinguished commissioners, petitioners, secretariat staff, and colleagues, it is an honor to appear before you today on behalf of ICE Enforcement and Removal Operations, or ERO. My name is Monica Burke, and I am the Assistant Director of the Custody Management Division within ICE ERO. I will provide information about ICE detention oversight, particularly updates that have occurred since the petitioners were detained in the early 2000s. This includes major changes since 2005 within ICE ERO Custody Management Division and the ICE Office of Professional Responsibility, as well as the creation of the ERO Contact Center of Operations and the DHS Office of the Immigration Detention Ombudsman. DHS meets its constitutional and statutory mandates, which are consistent with international human rights standards, by confining non-citizens in detention facilities that are safe, humane, and appropriately secure, and by implementing or mandating training requirements for all of its law enforcement personnel and detention staff. DHS is also responsible for monitoring performance and investigating alleged misconduct wherever warranted. Notably, I would also like to mention that most of our facilities that house the majority of our population are dedicated facilities where we house non-citizens separate and apart from other populations. We do use other types of facilities, but that is the vast majority of our population is detained in dedicated facilities, and they are separate from, again, other populations. I'd also like to note that we do allow protective custody, so we have individuals can be in special housing for protective custody reasons, not just for disciplinary segregation. The ICE ERO Custody Management Division provides policy and oversight for the administrative custody of ICE's highly transient and diverse population. ICE ERO employs more than 32 on-site federal detention service managers at key ICE detention facilities to monitor and inspect operations daily to ensure safe, secure, and humane conditions of confinement. The ICE Office of Professional Responsibility Inspections Division is responsible for the objective review of ICE offices and programs by assessing their compliance with federal law, applicable policies and procedures, and the agency's own detention standards. ICE OPR's Office of Detention Oversight conducts annual inspections of ICE facilities depending on how many non-citizens are detained there and for how long. These inspections assess facility compliance with ICE detention standards. The ERL Contact Center of Operations supports the ICE Detention Reporting and Information Line, or DRIL, a toll-free service that provides a direct channel for detained individuals, agency stakeholders, and the public to communicate with ICE to answer detention-related questions and resolve concerns. Concerns related to employee and contractor conduct may be submitted to ICE OPR, where they are reviewed by ICE OPR and the DHS Office of Inspector General. In 2019, Congress created the DHS Office of the Immigration Detention Ombudsman, or OIDO, which is the new office that oversees immigration detention. OIDO assists individuals with complaints about potential violations of immigration detention standards or misconduct by DHS or contract personnel, and includes conducting announced and unannounced inspection, and serves as an independent office to review and resolve problems. Additional layers of oversight are undertaken through site visits, investigations and audits from the ICE Health Service Corps, the U.S. Government Accountability Office, CRCL, and the U.S. Department of Labor, among others. These multiple channels of oversight enable ICE to provide and maintain a high standard of care for the detained population. As relevant to this case specifically, ICE no longer uses the facilities where the petitioners were housed. Specifically, those facilities are the San Pedro Service Processing Center, the Santa Ana County Jail, the Mira Loma Correction Center, and the Las Vegas City Jail. Finally, we understand from their petition that petitioners may be interested in conducting their yearly check-ins with ICE at a location other than the Los Angeles field office. ICE is amenable to having them report to a different location. We can follow up with petitioners and their advocates after this hearing, or their petitioners and advocates can reach out using the email address losangeles.outreach@ice.dhs.gov, or go online to www.ice.gov/check-in for more information about rescheduling a time and place for ICE check-ins. Thank you very much.
¿Concluyeron? ¿Sí?
Have you concluded? Yes? Thank you very much. I now ask the petitioner if they wish to use their right of rejoinder. You have 5 minutes.
To begin, I'd like to note that the brothers' claims were related to the wrongful imprisonment were already declared admissible by the Commission, so any arguments relating to admissibility are moot in this proceeding. Next, I'd like to turn to the allegations regarding
Más despacio para la C.
Please, if you could speak more slowly.
Regarding their immigration litigation. The statute of limitations requiring immigrants to bring an asylum claim within 1 year was not in place until 1996. As we've noted, all the brothers entered the United States prior to that period. Therefore, when they entered the United States, this requirement was not in place. The brothers have testified today about their desire and their attempts to bring witnesses on their behalf to their bond proceedings. This witness was intimidated by FBI agent Christopher Castillo and threatened with arrest and detention if he testified on the brothers' behalf. Likewise, the brothers attempted to bring evidence of their innocence in their civil proceedings, but the wrongful detention claims were thrown out by the district court at the motion to dismiss stage. It is inconceivable at this point that the United States would say that they were required to bring evidence on a claim that never made it to the trial court. They were precluded from bringing any written testimony on their behalf in their bond proceedings as well. As I noted, this case is not about the wrongfulness of the asylum, it's about the wrongfulness of their detention. Whether or not the petitioners appealed this asylum decision is not relevant for the purposes of this hearing. Regarding the facts that they settled their condition...
Estás hablando muy rápido.
You are speaking very, very quickly, and it's making it extremely difficult for the interpreters. Please, just a little slower. Thank you.
Regarding the fact that they settled their conditions claims for their detention, again, the conditions claims are not at issue today. What's at issue is the wrongfulness of their detention as a whole and the lack of due process that they've suffered over the last 2 decades. Whether or not claims that are related to this case but are not at issue today is not of relevance to the court and should not be considered. The United States also discussed the fault of the falsification of their documents. This was the fault of their immigration attorney, who has already been federally charged and convicted on these claims. the way he addressed petitioners was deceitful, and they were not aware that he was falsifying their documents. Again, this is not an issue for the Commission today. I would just like to address that point. Regarding the United States position on the fourth instance formula, both Marcioni and Carranza, the Commission said that a party may bring a claim even if it was issued by a domestic court acting within its competence and under its judicial guarantees, if a possible violation of the Convention has occurred, and specifically on the right to fair trial. Here, the petitioners are arguing that their right to fair trial has been violated, and they have sufficiently alleged several violations of the American Declaration both today and in their written testimony. With regard to the United States testimony regarding changes made to immigration detention, these changes have been made since the brothers' release, and they're irrelevant because they don't address the harms that the brothers suffered. The changes made since 2005 do not make the brothers whole. As they've aptly testified today, the brothers' abuses are long-standing and ongoing and must be remedied by the United States. The United States' refusal to remedy these abuses is part of a pattern of denying justice to individuals harmed by the state's rights abuses post 9/11. Many individuals have attempted to sue the United States and its agents in U.S. courts for the rights violations they have endured during this period. Yet, time and again, domestic courts have used procedural mechanisms to dismiss these claims. This hearing thus represents a unique and singular chance to have these claims heard on their merits, as is so often not the case in domestic courts. This case is also part of an ongoing and increasing effort by the United States to simultaneously restrict immigrants' ability to assert their rights through the judicial process and to grant immunity to federal government officials that violate those rights. Courthouse doors are closing to non-citizens in the United States who have a right to remedy under both national and international law. The United States is constricting the application of fundamental rights whenever they are linked, however loosely, to questions of immigration or citizenship, a clear violation of their obligations under the American Declaration. Thank you.
Bueno, muchas gracias.
Thank you. We have just about 14 seconds left. Would the state like to take the floor now in response?
Thank you. I'd like to say that we were in part of our responses were responsive to things that were said by the petitioners today, so wanted to make that clear. Additionally, some of the allegations that have been raised today are beyond the scope of the Commission. It appears that petitioners are now trying to make an actio popularis claim, which is beyond the competence of the Commission to entertain those claims. I'd like to turn it back over to my colleague to describe a little bit more about additional steps that DHS has taken, in part given Motion's testimony regarding segregation earlier today. Thank you.
Thank you for the opportunity to give a few follow-up remarks. The first thing I want to reiterate is that civil immigration detention is non-punitive. Once a non-citizen is transferred into ICE custody, ICE makes a custody determination based on a number of factors. With limited detention capacity, we use those resources to detain non-citizens to secure their presence for immigration proceedings or for eventual removal from the United States. That includes those whose release is prohibited by law, as provided by the Immigration and Nationality Act, or those that ICE determines would be a public safety risk or a flight risk during the custody determination process. It's very different from criminal detention in that way. And then second, briefly, on the issue of segregation or solitary confinement that petitioners noted in their petition, that they had been subject to segregation and detention. U.S. law prohibits the use of special management housing in a manner that would constitute cruel or unusual punishment or without due process of law. The United States remains committed to preventing abuses with regard to detention conditions generally, and in particular, protecting detained non-citizens from abuses and bringing to justice those who commit them. In September of 2013, after petitioner's detention admittedly, ICE issued a directive on the use of segregation for ICE detained non-citizens, which established enhanced ICE policy and procedures for the review and oversight of decisions to place ICE detained non-citizens in segregated housing for more than 14 days, or for any length of time in response to a health condition or a special vulnerability. This directive enhances reporting requirements and requires ICE to evaluate the appropriateness of continued segregation and to consider potential alternatives. In May of 2020, CRCL launched a periodic review of ICE's segregation oversight program. That review focused on how ICE headquarters and our field offices have implemented the requirements of the directive and the related policies and procedures. And on September 28th of last year, CRCL sent ICE a memorandum with 31 global system-wide recommendations to strengthen ICE oversight of segregation and better protect civil rights and civil liberties. Our segregation policies and oversight were also reviewed by the DHS Inspector General in October of 2021 and the Government Accountability Office in October of 2022. ICE is currently evaluating the segregation program and considering enhancements and changes in standards and oversight now. Thank you again for this opportunity to address the Commission.
Bueno, muchas gracias.
Thank you very much. I now ask the two parties to bear the time, in the interest of time, to please present further arguments in writing. At this time, I'll ask my colleagues to pose questions. Commissioner Roberta?
Thank you, Commissioner. Give me time. I'm asking Commissioner Esmeralda to give me time because I have so many questions and so many thoughts, but I'm going to be...
I can ask you.
Yeah. So you can, but I'll try to be disciplined. I have some questions for the state and one or two questions for the petitioners. So, as I understand it from the brothers, there were two periods of detention. Detention, I believe, in 1999, and then also detention in 2001. The detention in 1999, from what I can understand, was related to immigration irregularities. Is the state's assertion that the detention that took place in 2001 also related to immigration irregularities? Or is it that this detention was also related to allegations of terrorism? So what was the cause of the detention in 2001, and was it different from what happened in 1999? If charges of terrorism were also invoked to justify the detention in 2001, what was the evidence of that terrorism besides the LA cell list to reasonably support the framing of the detention as part of terrorism as part of the framing of the detention? And was that evidence supplied to the brothers, the evidence of terrorism besides the LA list and the attendance at the rally? Was that supplied to the brothers for them to respond to? On the question of the detention, I understand from the state that the detention in the context of immigration irregularities, which is why I come back to the question, what was the purpose of the detention in 2001? But immigration-related detention is not meant to be punitive. It's meant to secure the attendance, as I understand it, at immigration hearings. But what we've heard from the brothers seems quite punitive. They're being held in facilities with persons who have been convicted of serious crime. They're being held in facilities where they may not be allowed to leave the lockup for 3 or 4 days at a time. This is the testimony that the brothers have given, and that seems punitive because you can hold persons in kind of low security but secure facilities if it's, if it's about irregularities. So I'm wondering, and also thankful to hear the testimony on enhanced policies and the reform of detention conditions. But would you consider, as described and maybe as you have investigated, the detention conditions between 2001 and 2004? 5, would you consider that those conditions of detention may have crossed the line into cruel and unusual, particularly in the context if they were detained for immigration irregularities? And lastly, has there been any state review of charges of discriminatory detention on the basis of ethnicity post 9/11, and in particular in relation to the 4 brothers? Thank you.
Le paso la palabra a la comisionada.
I give the floor to Commissioner Mantilla.
Gracias, Presidenta. Well, only 2 or 3 things. For the petitioners, I'd like to know if there is any pending judicial proceedings against the brothers, and what about the status, migratory status, and also if the state, besides the agreement that they have, is there any other kind of support or reparation or remedies, because they both of them mentioned about the impact psychological, so I'd like to know if there is any support for them, for the health. Okay, and in the case of the state, okay, I'm not going to go further about the admissibility. I understand that you disagree, but the Commission already admitted the case, so, but just to mention, and I'm not going to mention either about the competence of the Commission, just like to remind, as I always do in the case of the state, about the Filartiga Peñeira case, what is very important about the law of nation, but only that. But the thing is that it really called my attention because there are 4 brothers. No, it was 1 or 2, there was 4. So it's kind of, I'd like to know if there are more situation of cases of brothers and family, all of them, detained. Second thing is that what about the migratory status? What about the migratory status of the brothers now? What is the current migratory status now? And just finally to remind that besides the American Declaration of Human Rights, besides the treaties, the non-discriminatory principle is part of the jus cogens. Even the restatement or law of the United States recognize the principle of non-discrimination. Just to remind that. Thank you.
Gracias, comisionada.
Thank you, Commissioner. Commissioner Caballero has the floor. Thanks very much, Madam President. I'd like to ask this to the representatives of the states of the U.S. along the lines that my colleagues, the commissioners, have already raised. Let me say the following. It would appear that there is being made an effort to make a distinction as among different levels or types of due process. And the question whether, as Commissioner Mantilla has just said, there are imperative international law norms that have a bearing here. And quite aside from the provisions of the American delegation and indeed due process as we see it here, due process in and of itself is surely very, very much involved with groups that are excluded, marginalized, ill-treated, et cetera, and so forth. And the difficulty for such groups to, according to their views, to access due process on equal conditions terms. And given the change of norms that have evolved, I wonder whether you might not, this is a question of the state, consider changes in considerations over time. Non-discrimination, the concept of non-discrimination, but also the concept of equality of arms, as it were, in terms of how the ethnic national origin issues can play in before U.S. courts, what bearing they can have before U.S. courts. There you go. Thank you, Commissioner. I'm going to give the floor to the Executive Secretary here, Jorge Mesa. Thank you, Chair and President, and very, very briefly, if you wish, ladies and gentlemen, to answer my questions in writing, you can do that. There has been an extrajudicial understanding with the state as to conditions of detention. What is the reparation? What is the period of time to which this applies, and what would you consider, if that came to that, due reparation? Thank you. The President. I would merely, for my part, underscore the importance that this commission ascribes to the analysis, to the study of the petitions as they relate to our own competence, as you've pointed out. And so I would echo the questions that my colleagues have already raised, underscoring most in particular the question of due process and the real possibility of access to justice that the brothers had in the development that we have heard of how their migratory status has evolved. To close, certainly, and most sincerely, I appreciate the participation and the presence of the distinguished delegation of the United States, that of the presumed victims, and reminder to both of you that as of today, as I speak, you have 30 days to present written considerations or objections. And with that, this hearing stands adjourned. Thank you.